Please note that this AI-generated podcast is intended solely for general learning and educational purposes. While we strive to ensure accuracy, the AI may occasionally produce errors or incomplete information. We strongly encourage you to consult qualified professionals and conduct your own due diligence before making any legal, financial, or business decisions based on the content presented here. Also, any views and opinions expressed in this podcast are those of the podcast creator alone and do not reflect or represent the views, positions, or policies of any organization, institution, or entity, past, present, or future, with which the creator is or may be affiliated.
Welcome to the Deep Dive. Today, we are tearing into really the blueprint of startup success. We're zeroing in on something absolutely crucial, but often misunderstood for founders. Intellectual property, IP.
It really is. We're talking about the core value driver, the thing that decides if your big idea actually has a defensible future.
Exactly. And, IP isn't just some legal thing tacked on at the end.
No, not at all.
Yeah.
For companies built on, say, new tech or really groundbreaking concept, IP is, well, quite literally the invisible shield around those brilliant breakthroughs.
Or the fuel for the rocket ship, as you put it.
Precisely. It's the engine.
And here's the reality check for every founder listening. For loads of startups, especially in tech, maybe biospaces, their intellectual property, it often makes up 80, 90, sometimes even 95% of their total asset value.
It's absolutely right. I mean, you could sell your desks, your laptops tomorrow for pennies.
Peanuts.
But your proprietary know-how, your core tech, that's the gold.
So our mission today is pretty comprehensive.
Yeah, we want to extract the actionable insights you need.
Mm-hmm.
Stuff on IP rights, how to protect things strategically, leveraging that IP for actual market growth.
And critically, how to avoid those, critical and incredibly costly mistakes. The kind that can sink a venture before you even get close to a Series A.
Yeah, the pitfalls are real.
Okay, let's dive straight into the fundamentals then. When we use the term IP, intellectual property, we're talking about creations of the mind. That sounds vast.
It is a bit broad, yeah. But it basically covers four main categories, which we'll get into. But generally, we mean things like inventions, literary works, artistic works, unique designs.
Logos, brand names.
Distinctive symbols, exactly. And also confidential business know-how, your trade secrets. These are all intangible assets that the law recognizes and, crucially, grants exclusive rights over.
Okay, so exclusive rights sound great for the inventor, the creator, but what's the bigger picture here? The societal argument. Doesn't giving someone a legal monopoly kind of restrict access to new ideas? Why does the government even encourage this?
That's a really critical question. And it gets to the heart of why IP exists. It's sort of twofold purpose. The first function is absolutely to incentivize innovation.
Right.
Think about it. If you didn't grant some kind of limited monopoly for a set period, why would anyone sink, potentially millions into R&D?
Because a competitor could just copy it instantly, for free.
Exactly. The original innovator would be almost guaranteed to lose money. So the promise of that temporary exclusivity, it encourages taking the risk.
So it's a necessary market mechanism, really?
You could say that.
Yeah.
But the second function is often overlooked, facilitating knowledge dissemination. It's like a societal bargain.
A bargain. How so?
Well, in exchange for that limited monopoly, this is especially true with patents, the creator is actually required to publicly disclose the exact details of their invention.
Ah, okay. So it's not about keeping it secret forever. You get protection for a while, but in return, the rest of the world gets the instruction manual, basically.
That's it, which allows others to eventually improve upon it or innovate around it once your protection expires. It fuels further progress.
That makes sense. So how does this translate for you, the founder? What's the direct value?
It translates directly into defensibility. When VCs, investors, are doing their due diligence, they are digging into your IP portfolio. They're gauging your defensibility, potential revenue streams like from licensing and, your odds of long-term market leadership.
They aren't just funding a cool product. They're funding a fortified position in the market.
Precisely. Your IP acts as that defensible moat around your startup. It makes it significantly harder for maybe better-funded competitors to just muscle their way into your market share.
And the strength of that moat that justifies the higher valuation VCs might give you.
Absolutely. It's fundamental to valuation.
Right. Okay, so let's open up this inventor's toolkit, as you called it. We've got 4 specialized tools. We need to know which one to grab for which job. Let's start with, I guess, the heavy hitter, patents.
Okay, patents. These grant exclusive legal rights to an invention, usually for about 20 years from the filing date. This is really the only tool that lets you proactively stop others from making, using, selling, or importing your invention.
And what kind of things are we talking about? Machines?
Machines, processes, manufactured articles, compositions of matter, even potentially software and business methods, though that gets complex.
Gotcha. And I can't just patent any old idea, right? There are hurdles.
Definitely not just any idea. You need to meet the big 3 requirements. First, novelty. It has to be genuinely new, not previously disclosed anywhere in the world.
Okay, this is the file first, talk later rule we always hear. Let's stress the consequence here. Say I talk about my invention, maybe in detail, at a pitch competition or on a blog before filing. What actually happens?
You might have just completely destroyed your chances of getting patent protection in almost every major international market. It's that serious. Most countries have what's called an absolute novelty system. Any public disclosure before filing can be a death sentence for your international patent rights. It's probably the #1 most catastrophic blunder early-stage companies make with IP.
Okay, message received. File first. What are the other requirements?
Second, the inventive step. It can't be obvious to someone who's already skilled in that particular field. Just putting wheels on a suitcase probably wouldn't cut it today unless the way you attach them was truly novel.
Makes sense. And the third?
Third is industrial applicability. It has to have some practical use. You need to be able to actually make it or use it in some industry. It can't just be a purely theoretical concept.
Okay. Now, getting a full patent, that sounds like a long, expensive process. Is there a shortcut or maybe a stepping stone for lean founders?
Yes, absolutely. The provisional patent application, this is your critical first friend.
Provisional. Okay, what does that do?
It basically acts as a placeholder. It secures an early filing date, that crucial priority date, and it lets you legally use the term patent pending.
Ah, patent pending. That sounds useful.
It is. And importantly, it buys you a full year. 1 year to refine the invention, test the market waters, maybe raise the funds you need before you have to commit to the full, much more expensive non-provisional application. A fantastic time and money management tool for startups.
Excellent tip. Okay, tool number 2, trademarks. This is all about the brand, right?
Exactly. Trademarks protect your brand identifiers. We're talking names, logos, slogans, sometimes even specific sounds like the Intel chime or distinctive colors like Tiffany blue.
And the goal here is
The core job of a trademark is to prevent consumer confusion about the source of goods or services, making sure people know it's your product or service, not someone else's.
now, if I just start using a unique business name, say tomorrow, do I get any protection automatically?
You do gain some limited rights, called common law rights, just through use, but these are usually confined to your local geographic area.
So not great if you want to scale nationally or internationally.
Right. For that kind of scale, or for serious investment, you really need registration. Federal or international registration gives you much stronger rights, provides formal notice across the whole country or region, and makes enforcing your rights way simpler and cheaper if someone copies you.
And the brand itself becomes a really valuable asset, doesn't it? Especially at exit.
Hugely valuable. Trademarks safeguard your reputation, your customer goodwill. They often command high valuation multiples during an acquisition because they represent that established market presence.
So what's the key best practice here to avoid early pain?
Do a thorough trademark clearance search before you launch. Seriously, before you spend a single cent on designing logos, printing business cards, or building the website.
Why so early?
Because finding out later that a similar mark already exists in your industry forces a devastatingly expensive and time-consuming rebrand. Just imagine. Secure the name, grab the domain names, the social media handles, do it all early.
Sound advice. Okay, tool number 3, copyright. What does this cover?
Copyright protects the original expression of an idea, not the underlying idea or concept itself.
So the way it's expressed, like source code.
Exactly. Source code's a big one. Also, website content, marketing materials, music, art, maybe unique user interface layouts, the text in your pitch deck.
And how do you get copyright protection? Is there a form?
Well, the interesting thing about copyright is that protection is automatic the moment you create something original and fix it in a tangible form, like typing code, writing text, recording music.
Automatic, so no registration needed.
The right exists automatically, yes. But, like trademarks, registration makes enforcement much easier and gives you access to certain legal remedies like statutory damages if you need to sue someone.
Okay. But what's the single biggest landmine for a tech startup when it comes to copyright? I'm guessing it's about who actually owns the code.
You nailed it. It is the single biggest stumbling block I see derailing funding rounds. Ownership.
How does that happen?
Well, say you hire an external developer, a freelancer, to build your core platform. The default legal position in many places is that the individual developer owns the copyright in the code they wrote.
Wait, even if the company paid them for the work?
Even if you pay them, unless there is a clear written assignment clause in their contract or a proper work for hire agreement that explicitly transfers ownership of that IP to the company.
Wow. Okay, I remember that scenario we discussed, the founder whose Series A nearly collapsed entirely because they couldn't find the signed IP assignment agreement for their core code. How often do VCs actually look for that piece of paper?
Every single time. It's usually one of the very first legal documents VCs ask for during due diligence. Think about it. If you don't unequivocally own your core technology, you don't actually have a defensible business for them to invest in.
That founder's nightmare. It's a real risk if you treat legal contracts as just boilerplate.
It absolutely is. Get it in writing from everyone, employees, contractors, freelancers, no exceptions.
Crystal clear. Okay, tool number 4, trade secrets. This one feels a bit different. It's about secrecy.
It is. A trade secret is confidential business information that gives you a commercial edge specifically because it's not generally known.
Like the Coca-Cola recipe.
That's the classic example. Or Google's core search algorithm, maybe a detailed customer list, a unique manufacturing process, information that has value because it's secret.
And unlike the other 3 IP types, there's no registration process here, right? Protection depends entirely on your actions.
Exactly. Protection comes entirely from actively keeping it secret. That means using robust non-disclosure agreements, NDAs, having strict internal security protocols, both digital and physical, and implementing need-to-know access controls. Only people who absolutely need the information get it.
So it requires ongoing effort, policies, training.
Definitely. Companies need clear policies, maybe access logs, regular employee education, especially during onboarding, and importantly, during exit interviews to document that they're making reasonable efforts to maintain secrecy.
What's the big advantage here and the big risk?
The advantage is huge, potentially indefinite protection. Unlike a patent that expires after 20 years, a trade secret can last forever, as long as it stays secret.
But the risk?
The risk is equally huge. Protection vanishes instantly if the secret is independently discovered by someone else, if it's successfully reverse engineered, or if you lose control through a leak, especially one you didn't take reasonable steps to prevent. Once it's out, it's out.
Okay, so we have a toolkit. Patents, trademarks, copyrights, trade secrets. Now let's talk strategy. How does a founder move from just understanding these tools to actually building a proactive IP strategy, not just reacting to threats?
Yeah, it absolutely has to be proactive. It should start with an IP audit, ideally right at the earliest stages. Systematically identify everything you're creating that could be an IP asset.
And then prioritize. You can't protect everything perfectly.
Exactly. You have to prioritize based on your core business model. For instance, a direct-to-consumer e-commerce brand. They'll likely prioritize trademarks heavily. A deep tech AI startup. They might focus more on documenting trade secrets meticulously and perhaps filing some very strategic, complex software patents.
So the strategy needs to evolve with the business.
It has to be a living document. It needs to align with your product roadmap, your market expansion plans. It's not a one-and-done thing.
Right. What about going global? You mentioned IP rights or territorial country by country. That sounds incredibly expensive, filing everywhere.
It is prohibitively expensive to file everywhere individually. A U.S. patent only protects you in the U.S., a U.K. trademark only in the U.K., and so on.
So how do startups manage that? Are there workarounds?
There are streamlining mechanisms, essentially ways to buy time and coordinate international filings more efficiently. For patents, the big one is the Patent Cooperation Treaty, the PCT.
The PCT, how does that actually help a founder?
Okay, so instead of rushing to file in dozens of countries immediately, you file one international PCT application. This acts like a reservation, securing your right to seek patent protection later in over 150 member countries.
And how much time does that buy you?
It buys you a critical 30 or sometimes 31 months from your initial filing date. That's 2.5 years.
Wow.
Yeah, 2.5 years to further develop the invention, assess foreign markets, maybe secure partnerships, and raise the significant funding needed before you have to commit to the very high costs of entering the national phase, filing separate applications in specific countries like China, Japan, across Europe, etc.
That 30-month runway sounds like a massive strategic and financial advantage. Is there something similar for trademarks?
Yes, the Madrid Protocol, it offers a similar streamlined process. You file one international application and can designate multiple member countries where you want to seek trademark protection simultaneously. It simplifies the process significantly compared to filing individually in each country.
Okay, so IP isn't just a defensive shield. You mentioned leveraging it. How can startups actively use their IP for offense, for generating revenue?
Licensing is probably the most common method. This basically means giving permission to another company to use your IP. Could be a patent, a trademark, maybe some technical know-how in exchange for payment.
And there's flexibility in how you structure these deals.
Oh, huge flexibility. You can grant an exclusive license. Only they can use it, or non-exclusive, multiple companies can. You can also limit the license to a specific field of use.
Can you give an example of that field of use restriction?
Sure. Let's say you've developed a novel battery technology. You could license it exclusively to Company A, but only for use in medical devices.
Okay.
Then you could simultaneously license the same core technology to Company B, but only for use in, say, electric scooters.
Okay.
Different market, same underlying IP, maximizing your revenue streams.
Smart. And what kind of payments come from these licensing deals?
Typically, you'll see ongoing royalties, which are usually a percentage of the licensee sales using your IP. You might also get upfront license fees, which provide immediate cash flow, which is great for startups. And often, there are milestone payments.
Milestone payments.
Triggered when the licensee achieves specific development or commercial targets. For example, in biotech, maybe completing a phase 2 clinical trial using your patented compound triggers a multi-million-dollar payment. IP can also sometimes be used as collateral for IP-backed loans.
Interesting. Okay, let's shift back to risk avoidance. We really need to make sure listeners avoid those common, potentially fatal pitfalls. We hammered the public disclosure pitfall file before you talk. What's the second major mistake founders make?
Inadequate record keeping and, relatedly, ownership clarity. We touched on getting those assignment clauses in writing, which is vital. But beyond the contracts, you absolutely must meticulously document the invention process itself.
Meaning, who invented what and when?
Yes, exactly. Failure to properly document who contributed, what inventive concept, and precisely when they did it. Maybe using time-stamped code commits in Git, signed lab notebooks, formal invention disclosure forms, it severely undermines your ability to prove ownership, or even establish novelty if you end up in a dispute or litigation.
So without that paper trail.
Without that proof, a simple dispute can turn into a hideously complex and expensive fight over basic facts. You might struggle to prove you actually invented it first.
Essentially, if you can't prove you built it, and when legally it gets very messy, you might as well not have built it.
It can feel that way in a dispute, yes. The third big mistake is being reactive rather than proactive in enforcement.
Waiting too long to act when someone copies you.
Exactly. Waiting until a competitor has deeply copied your product, maybe saturated the market with knockoffs. Trying to claw back that market share through litigation at that point is exponentially more difficult and costly. We're talking potentially millions in legal fees.
So what's the proactive approach?
You need to actively monitor the market. Use IP Watch services if appropriate. When you spot infringement, send professional cease and desist letters promptly. Don't delay, and leverage platform takedown mechanisms like on Amazon or app stores immediately. Be vigilant and act fast.
Makes sense. Now, speaking of cost and risk, how does all this IP stuff play into getting funding, like from a venture capitalist? How closely do they look during due diligence?
Oh, it's absolutely central to the negotiation and the investment decision. VCs, or rather their lawyers, will almost always demand something called a freedom to operate analysis, or FTO.
Freedom to operate, FTO, what are they looking for there?
They're assessing whether your product or service potentially infringes on any existing third-party IP rights. So it's not just about whether you own your IP.
It's about whether launching your product is going to land you, and by extension them, in a massive lawsuit.
Precisely. They want to ensure they aren't funding a future multi-million-dollar legal battle against some larger established player who already holds patents in this. You're right, it's very dynamic. Probably the biggest one creating waves right now is AI-generated inventions and creations.
AI writing code, designing things.
Exactly. AI systems can now autonomously or semi-autonomously generate potentially patentable inventions or copyrightable works. But current patent law, in most places, generally requires a human inventor. The law is seriously lagging behind the technology here.
So that creates a huge ambiguity, right? If the AI system genuinely invents something, who owns the resulting IP? The person who designed the AI, the user who prompted it, the company that owns the data it trained on.
That is the massive, open legal question everyone is grappling with. There's no clear answer yet in most jurisdictions. So until the laws catch up, the best practice for startups using AI heavily in R&D is to meticulously document all human involvement.
How so?
Document the human oversight, the direction provided to the AI, the selection process, any refinement of the AI's output. Frame it so you can argue the AI was merely a very sophisticated tool used by a human inventor rather than the sole autonomous creator itself. That's the safest path for now.
Fascinating challenge. Okay, trend 2, you mentioned this is a massive landmine, especially for software companies. Open source software, OSS, compliance.
Yes, this one can be devastating if ignored. The risk comes from certain types of strong copyleft licenses, like the GNU General Public License or GPL.
Copyleft, what's the danger there?
These licenses often operate under viral terms, meaning if a startup unknowingly incorporates or even links its proprietary code to an OSS component governed by a strict copyleft license, they might find themselves legally obligated to release their own valuable proprietary source code to the public under the same open source terms.
Wait, seriously, using just one library or piece of open source code with the wrong license could force a company to effectively give away its entire secret sauce.
Wow.
That sounds catastrophic.
It absolutely is. It's a potential IP disaster. That's why startups must implement robust open source policies. They need procedures to vet the licenses of any OSS they use, and ideally use automated dependency scanning tools to track all the licenses within their code base and ensure compatibility. You simply cannot afford to be surprised by an incompatible license after your product is built.
Wow, okay. Definitely something to watch. And the final trend you wanted to touch on, how is blockchain technology starting to impact IP management?
Blockchain offers some really exciting potential, particularly around documentation and transaction efficiency. We're seeing promising uses like decentralized timestamping of creative works.
Like a digital notary.
Exactly. Creating an immutable, publicly verifiable record of when a creation existed, which could be useful for proving prior art in patent disputes or establishing originality for copyright. We're also seeing potential for smart contracts built on blockchain.
To do what?
To potentially automate royalty payments for licensed IP. Imagine royalties flowing automatically based on usage data recorded on the blockchain, bypassing slow, expensive intermediaries. There's also exploration of tokenization of IP rights, like creating fractional ownership of patents or copyrights.
So selling shares in a patent.
Sort of, yeah. But the main challenge here is still standardization and gaining broader legal recognition and acceptance of these blockchain-based records and transactions within traditional court systems. It's still early days, but the potential is there.
Okay, so we've covered a huge amount of ground from the fundamentals, the toolkit, strategy, monetization, pitfalls, and even future trends. The big message seems clear. IP is absolutely not just some bureaucratic chore.
Not at all. It is the engine of sustained growth. It's a central strategic component of your business right from day one.
All right, let's crystallize this. What are the 4 key takeaways for a founder listening right now?
Okay, number 1, IP is a strategic asset. Remember, it's often your most valuable asset. It's crucial for justifying your valuation and, critically, for establishing that defensible competitive advantage. You've got to build the moat before the competitors show up with bigger shovels.
Got it. Takeaway number 2.
Proactive protection is key. Don't wait. File early, especially that provisional patent. Secure clear ownership in writing. Hammer home those assignment clauses with absolutely everyone who touches your tech or creative work. And maintain meticulous records of invention.
Makes sense. Number 3.
IP fuels growth and investment. A strong, clean IP portfolio doesn't just defend, it attracts VCs. It signals market leadership potential, and it enables powerful monetization opportunities through things like flexible licensing arrangements. It's fuel for the rocket ship.
Then finally, number 4.
Stay aware of emerging trends. The IP landscape is changing fast, driven by tech like AI, the complexities of open source, and the potential of blockchain. You need ongoing adaptation and vigilance to avoid falling behind, making legal missteps, or missing new opportunities.
Knowledge is the greatest shield, as you said earlier.
It truly is in this space.
Indeed. So, the final thought to leave everyone with today is this. Stop thinking about your next big idea just as a product or maybe a service. Start thinking about it right now as a potentially defensible strategic asset that's waiting to be secured. So the question for you is, what steps will you take, maybe even today or this week, to secure its future? How will you transform it from just a fleeting concept into an enduring protected asset that can genuinely drive your success?
Thanks for tuning in to the full episode. If there's any topic or case law you'd like us to cover next, share your suggestion in the comments on our latest video. And if you found value in the podcast, don't forget to like, subscribe, and hit the bell icon to stay updated.